Welcome to Khanversations. I'm Muqtedar Khan, and today I have with me Professor Wayne Batches, who is a very prominent scholar of the First Amendment and constitutional law. He teaches at the University of Delaware. He's my neighbor. His office is 4 feet away from my office. And for those who watch Khanversations regularly, you may recognize that Professor Batches was on Khanversations to discuss his most recent book, Throwing the Party. We try to understand the intersection of law, politics within the American government's context when we had that conversation. But today we are going to talk about something which is both, shall we say, constitutive to the Western society as well as most, shall we say, disrupted idea at the moment in Western societies, especially on both sides of the Atlantic, UK as well as in the US, the issue of free speech. What is free speech? Are there any limits to free speech? What is hate speech? And I'm sure that Professor Batches will explain to us that America is probably the only place on earth where we come closest to absolute protection of freedom of speech. We come closest to that, unlike European and other countries in the world, which have all kinds of limits on freedom of speech. Freedom of speech is fundamental because it is through, see, when you control what someone says, you also control what someone thinks and what someone reads or what someone writes. So for a society to be truly free, I think the First Amendment is the first thing that has to be there, which is that you should be able to express what is in your mind. Otherwise, there are no freedoms. So we will begin. Professor Wayne Batches, welcome to Khanversations.
Thank you so much for having me. This is a great pleasure.
So I'm going to start off right away from the deep end of the pool. What is free speech and what is hate speech?
Wow, what is free speech? Well, that is not a simple question, right? I think the most obvious answer, right, is free speech is the ability to express oneself, right, and that can include many different kinds of expression, right? We talk about I teach an entire class on the First Amendment, right, and it's intuitive, but not always something we think about, that speech comes in so many forms, right? When we talk about speech, we're generally talking about, and certainly the court has interpreted the First Amendment to include other forms of expression, artistic expression, certainly writing, but so speech is broad, right? Speech is a very broad concept. What is hate speech? Right? Hate speech can mean many things. This has become something we've been talking about a lot recently in the last week or so in the United States. It's a contested concept, right? Traditionally, it's understood to mean speech that is demeaning of particular groups based on race or religion or gender, things such as that. But the concept, of course, is quite malleable, right? And this is, I think, the concern many people have when discussing hate speech as a discrete category, because it really is something that is in the eye of the beholder, right? We all disagree or have different views on what is or is not hateful, and so generally, under First Amendment doctrine and the way the court has interpreted the First Amendment, it is not seen hate speech as a discrete category that is treated differently from other kinds of speech. And as Dr. Khan mentioned at the beginning, right, this stands in contrast to a lot of other countries that do, in fact, carve out hate speech as a lesser protected category of speech.
But is there a legal definition in the United States of what is hate speech? You know, lately I have learned that having a constitution and then there is law, right? So there are certain things which come from the constitution, and there's something that comes from how the legal tradition has interpreted the constitution. So you could actually have text in the Constitution which says one thing, but the legal understanding of that could be different. So, is there any constitutional or legal understanding of hate speech in the US?
Yeah, I mean, you raise a really important point, and this is something that's true. It's particularly true of American constitutional law because our Constitution is so old and it's so short. And if you look at the First Amendment, right, there's very few words in that First Amendment. So it doesn't. The First Amendment does not lay out what is included in speech and what is not. There is no legal definition of hate speech in the United States because the court has not deemed it to be a distinctive legal category. That doesn't mean that politically there has not been, a lot of, there isn't something that we might say is hate speech that is real, right? But there are many different definitions.
So this is it, right? This is the First Amendment. And if you look at it, when we are talking about speech, there's just a few words. Like the first part is about religion. Congress shall make no laws respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or the right of the people to peaceable assembly, etc. So it's not even a full sentence really in the Constitution on freedom of speech.
So we have a sort of a common law, what we might call a common law approach to interpreting our Constitution. Those very few words, and that means it's and when I teach my classes, students are surprised sometimes at how much we're not really even focusing on the Constitution, the words of the Constitution itself, because under our system we have just a buildup of interpretation by courts. Hate speech is again something that has not been identified as a relevant category. Now, we might say that according to many people's definition, right, the court has dealt with many matters that address hate speech, right? So you could look at there's a case from about 15 years ago, a group called the Westboro Baptist Church, a small church, basically a family, received a huge deal of attention by protesting at the funerals of soldiers, and they would protest holding signs with very offensive statements on those signs, right? That basically suggest that American soldiers were dying as a form of punishment from God for our view toward homosexuality, right? That we have and they protested at these funerals to significant effect. Then they received a lot of attention, as I said, and eventually it landed in the Supreme Court. And the Supreme Court, now by most definitions, right? On these signs there was you might say the F word as a pejorative for gay people. There was very offensive sentiments that were expressed on these signs. Hate speech by most definitions. The court said this is protected speech, protected even from a civil lawsuit by the family of a fallen soldier who was simply requesting compensation for the emotional harm that they suffered, and the court was quite clear, and that was a not unanimous but close to unanimous decision. So there are many cases where the court has handled speech that most would define as hate speech, but has not seen it as a legally relevant category in itself.
If it is not legally category, then how would you prosecute it? Like, what would you say? What would the prosecutor say? I'm charging this person with.
You wouldn't, right? Because it's protected under American law. It is protected. Now, it may not be protected under certain circumstances, right? If that speech constitutes what the court has called a true threat, for example, right? And that means using again, words, right? This is one of the rare exceptions to the First Amendment, to put someone in a reasonable feeling of a threat to their physical safety, right? And that is criminal. It is a crime, right, to threaten someone, and that can take the form of hate speech, right? The issue there in front of the court, suppose the N word were used, or any other very vile kind of slur were used as part of this threat to someone's safety. There was a case from about 20 years ago in which the court concluded that under certain circumstances, cross burnings by the Ku Klux Klan, right, because of the history of the burning of crosses as a way of intimidating and threatening people and making them feel unsafe and as if their families and their own lives were at risk. That could be considered a true threat that is not protected under certain circumstances by the Constitution. So it would have to be something that falls into one of these narrow categories.
I was very surprised once when I read the legal definition of assault and battery. So battery is when I physically hit somebody, but assault is when I just scream at somebody, isn't it? I don't have to have a physical contact in order to be accused of assaulting someone. So if someone does commit hate speech, you could charge them with assault, isn't it? Without saying this is hate speech.
Yes, if you put that person in a you give that person a feeling of physical insecurity and give them the impression that you are going to hurt them at that imminently. Yeah, certainly, right. So this is why free speech law is a very complex area of law. It used to be that the First Amendment was taught as part of a general constitutional law class. And since the 60s and 70s, the area has just grown and grown and grown in complexity, and so now it's generally taught as its own course, and students take it as an elective, which I think actually in most law schools, and I think that's actually a mistake because I think it is so crucial.
So when people say that you have a certain right, whatever that right is, what we really mean is that, like you say, that I have a right to life. Now, that is one of the most stupidest thing to say because everybody dies. So theoretically, none of us has a right to a life. We could die, during this show. But what it really means is that the state does not have the authority or power to take my life without due process, right? That's what it means. That the state cannot abridge or contain any of those things that we consider right as right, without a due process, or maybe that even if they have due process, like when we ban capital punishment, for example, we prohibit the state from taking that. So when we say that we have a right to free speech, it really means that only the state doesn't have the right to curtail my speech. But what about civil society? What about corporations? What about universities?
That's absolutely right, and that's a really common misconception, that the First Amendment applies to private entities, like corporations or private individuals. The First Amendment and the Constitution itself is a limit on the government, right? And so this also, though, is a little more complicated than it might seem at first glance, right? So a private employer has every right to limit your speech, to limit the speech of its employees. A private host to a dinner party, right, has every right to kick out a guest whose speech that host finds repugnant. Mm-hmm. But even this area is a little complicated, right? Because there is some overlap, certainly, right? And we are having this discussion today, right? As we see, we have a government in the United States that is using the power of the government in a much more overt, and some would say aggressive manner than we've seen with previous presidents. So there's a question of uh, when private actors are perhaps responding to pressure coming from the government, right? Is that then still something that is purely private, or where is the where's the overlap, right, between government action and private action, and those are issues that have to be sort of fleshed out, I think, by the courts, and we're seeing a very different kind of government than we're used to in the United States, which means we're going to see a lot of, and we have seen a lot of litigation, and that's going to be true in the area of First Amendment law as well.
So take the analogy of equal opportunity, right? We can force private corporations to ensure that they don't discriminate people based on the certain protected categories. So why can't speech also be protected in a similar way? Because speech is a public good that the state provides. So why should non any entity be authorized to curtail that public good which the state provides? It's like saying the state has created a highway and I can drive on it. And then someone tells me, no, you can't drive on it because we maintain the road or whatever. Do you see what I mean?
Yeah, well, so there is something in the highway analogy. What we there is something called the public forum doctrine, right? So the government can create, using its own land, a park, right, and a public park, and the court has said there are certain kinds of government creations where we still have to protect private speech, in this place, even though the government is controlling it for its own purposes, creating it for its own purposes. So that's a kind of an area where there's a kind of a bit of a blurring. But so your question was, how about imposing these principles of free speech on private actors? The other question is because we think it's a good thing, right? The organization FIRE, for example, it's a free speech organization that has, some would say, kind of taken over the ACLU's role as being, primarily and solely about protecting free expression. They argue that even private entities, like private universities, should, even if they're not obligated to under the Constitution, be concerned and aware of respecting a diversity of speech on their campuses. It may not be required by the Constitution, but that doesn't mean we still can't, as a society, argue that certain private actors also should respect certain free speech principles.
I will come back to the universities. I have a couple of very serious questions about our universities and their role. But I want to refer to this statement that was made by our Attorney General, Pam Bondi, which is creating a lot of controversy, where she has threatened to go after people who indulge in hate speech. And so I don't understand what does that really mean, that she's going to go, like, what is hate speech, what Pam Bondi doesn't like, and in fact she then tried to correct herself by saying hate speech that crosses the line. And now I'm even more confused as to hate speech, if there is such a thing. I mean, Europeans will understand what hate speech means, but hate speech is hate speech because it has already crossed a line, isn't it? Now, is another line there, which she wants to say you can indulge in hate speech, but up to this line. Beyond this, I will come after you. Do you think it makes sense, or should we just dismiss her as a moronic statement?
Well, I think I would applaud her for correcting herself, right? And I would suggest that she perhaps realized that what she said was not consistent with the court's interpretation of the First Amendment. And so her correction was, I think, defensible, right? The idea that, yes, there are some lines, right, as I said, with certain hate speech, right, as we might define it, that would not be protected. So one is true threats, another is incitement of criminality or violence, right? That is another exception the court has carved out to the First Amendment. It's a very narrow exception. So again, and the seminal case on incitement in the modern era was a case from the late 60s in which, again, the KKK, right, said what they were burning a cross on film, and they said they used numerous racial slurs and said if the Congress and the president and I believe the courts, if I'm getting this correctly, I'm just paraphrasing from memory, don't respect the rights of white people in this country. Well, some revengeance will have to be taken. That was the phrase they used. And the court, in that very important decision, Brandenburg, said that that was protected speech, that it still didn't rise to the level of unprotected incitement, because unprotected incitement has to be directed at causing people to violate the law or act violently. And it has to be likely that they will, and it has to be imminent. It has to be something that will occur immediately, right? And the idea there is that it is a emergency situation, right, where there is no time to pull back and correct misguided speech with counter speech.
So Pam Boundary's threat herself, I mean, what she said was a threat, right? Does that rise to the level of hate speech?
I want to pine on whether her speech itself would be considered hate speech, but
by her first statement, it would be, isn't it? She said,
yeah.
"I will prosecute you. I will chase. I will not let you guys go," or whatever. It was very threatening. I was scared the moment I saw it.
Yeah, I mean, there are definitely some very big questions here about this administration, and just as recent as last year, the court unanimously, the liberals and the conservatives together, agreed that this was out of New York, and it had to do with the National Rifle Association, and an attempt by the government in New York to affect the advocacy of the National Rifle Association, and the court, not deciding a matter with finality on its merits, but sending it back to the lower court, was quite clear that coercion by the government can be a violation of the First Amendment. So using the power of the government to cause people to silence others or deprive others of their free speech can certainly constitute a First Amendment claim. So we shall see, right? We shall see if some of these actions by our administration, some of these statements by our administration, make it to the courts, and are understood as government action that potentially violates free speech.
You're going to be surprised by who I'm going to quote next. Megyn Kelly. So she's been going after Pam Bondi. What is both interesting and sad that the most interesting discussion on this topic is happening on the right and not on the left. Really, from both sides, the debate is mostly among the MAGA crowd. They are debating this whole issue, where she argues that there is absolutely no such thing as a hate crime. Tucker Carlson also says that they're all saying there is no such thing as a hate crime. So when Pam Bondi was basically reacting to the criticism coming from the far right rather than from the far left. And so she went back and tried to correct, but she still used the word hate speech and said when hate speech crosses a certain line. So Megyn Kelly's answer was, she said, well, I welcome this, but she should have said when a threat or something else without using the word hate speech. When your offensive language or whatever you're doing, that crosses a certain line, then we will go after you. But they are adamant that there is no such thing as hate speech. And what is protected by the First Amendment is actually hate speech.
Yeah, what we're seeing is pretty fascinating, actually. I mean, as well as distressing, but this concept of hate speech, of course, um, uh, on the left, right, was cultivated for many years, right? And certainly in other countries there are hate speech laws, right? Hate speech is an unprotected category of speech, so it's not something that was pulled completely out of the ether. But I do think, right, that very recently, right, it was the right that sometimes was in the position of resisting calls from some on the left to distinguish between hate speech and free speech. Um, and so there is the First Amendment, and is one of the reasons I've always been attracted to the First Amendment, um, is not ideological, right? I mean, and there are periods in our history when the biggest threats to the First Amendment, or some significant threats at least, I would argue, are coming from the left, and there are periods of time when the threats are coming more from the right. And this is why I think FIRE is such a fascinating organization, a Foundation for Individual Rights and it used to be the Foundation for Individual Rights and Education, and I think they changed what it stands for now. They have a broader mission, but they have real diversity when it comes to the ideology of those who work there. It's actually based in Philadelphia, where I live. Because the belief in free expression is not bounded by ideology. If you really believe in free speech, you have to believe in free speech for those you support and those you strongly oppose.
So free speech is a very broad category, right? That you can think aloud and like, can I speculate the fact that human beings are just figments of the imagination of someone, like talk about, like Matrix talked about it. These are all stuff. But how's this new idea of hate speech, which is actually quite developed in Europe? It is limited by the European Commission. And so there are protected categories of people against whom you cannot express certain opinions. And so you are liable to be prosecuted, even on social media, etc. But how is this different from medieval prosecution for blasphemy?
It's an excellent question. I mean, I quite frankly find it somewhat surprising that we are such an outlier when it comes to freedom of expression. That so many remarkably advanced societies throughout the world don't grasp, right, the need for consistency and the risk of once you open up the possibility of not protecting something called hate speech, right? That you are opening up the possibility that when it's an administration that you do not support, right, you will be the one being targeted of spewing hate speech, right? And it is that protection from government, right, from an overreaching government that decides what speech is permissible and what speech is hate speech, that the framers were trying to protect us from. So I find it somewhat at times distressing that European countries with otherwise remarkably advanced societies and laws don't don't see this the same way?
Uh, so one thing is what is right according to law, and the other is how the governments choose to execute those laws. So they can be very selective and prejudicial in the manner in which they implement law. So if you are critical of one concept or one community or one country, you could be in deep trouble. But if you don't do the same, if you can do the same thing against others. So for example, you can say whatever you like about Prophet Muhammad and draw whatever you like, etc. And it's protected by free speech. So when the Salman Rushdie book came out, if you remember, this was more than 25 years ago in the UK. I was just an engineering student at that time, but I was one of the few people who was arguing what would happen in England if if such a book was written, which was making mockery of Jesus Christ. And I at that time I learned that Great Britain had blasphemy laws protecting Jesus, but those blasphemy laws did not extend their protection to Prophet Muhammad. So rather than extending protection to Prophet Muhammad, peace be upon him, they basically removed the whole bunch of laws. They unprotected even Jesus Christ. Now you can probably write such books. But to me, the understanding was that these laws do not evolve unless they are tested, right? So are we going through a phase where we are really going to test the First Amendment and its limits in the political context? Because I think the First Amendment is essentially a reaction to all that happened in Europe because of religion. That's why they are both in the same category. So that First Amendment was freedom from being accused for blasphemy, even though we did burn witches here in the US too. But now we are going through an era where we are trying to really test the First Amendment and see how it can be rethought, reimagined in the context of ideology.
Yeah, it's a great point, right? I mean, there's a great example, right, of where whenever the government gets in the business of deciding what is sufficiently hateful and what isn't, there's going to be resentment, right, from Muslims who, for example, right, are treated differently when it comes to speech than Christians, right? And now you explained that of course, the solution there was to get rid of blasphemy laws. But I think similar kinds of natural tensions emerge with hate speech laws when it's certain groups, right? Certain groups may not be criticized, but other groups may, and there is going to always be a kind of resentment that will come out of that, right? That can't play out. It doesn't have an outlet in the political sphere because you are silencing that discussion, right? So by its very nature, it is anti-democratic, and with democracy and free expression, there is always an outlet, right? There is always an outlet to debate policy choices. There is always an outlet to debate the consequences of different criminal behavior. There is even an outlet. I mean, now I know that these terms are can be have multiple meanings. But you mentioned hate speech and I think you said, did you say hate crimes or
Hate crimes, yeah.
yeah? So I mean, so those are very different things, right? And so if we think that as a society that certain kinds of criminality that are motivated by racial hatred, for example, should be punished to a greater extent than other kinds of crimes, we can decide that is so, and that is not a violation of the First Amendment. But in a free society, in a free speech guided society, we can debate that and we can argue that, well, there might be some other motivations that I think also should have this heightened penalty, and we can freely debate that. Once you get in the business of silencing certain kinds of critical remarks or points of view, then that shuts down that democratic process, and that's why I think it's so dangerous.
Is academic protected by freedom of speech, by the First Amendment?
Um, Complicated answer. Generally, no. All right. Private academic institutions can make their own choices. Right. They can decide um, who to hire, who to fire, who to provide with tenure. Now, tenure may be a contractual issue, which is a matter of law, but not of constitutional law. Um, so this is one of those areas where certainly with private institutions, there is an ethic we call academic freedom, right? That has been around for well established for some time in this country. The AAUP over 100 years ago laid down some core principles, right? That we academics take very seriously about the importance of freedom of academic inquiry, and freedom when it comes to our classrooms, right? Because that's understood to be essential for us to fulfill our mission, which is the search for truth. So it is a principle that is enforced by not the Constitution, but by I think the continued belief that academic freedom is essential.
So one of the challenges that I don't know whether you're following this, there's a curriculum battle going on in California about whether you can teach colonial history of colonialism or not. I teach politics of development, and this week I was teaching colonialism and decolonization. We cannot explain the underdevelopment of some countries without talking about colonialism. So how can I teach our students how to develop and how to these pathways? And so if there are two issues. One, the government itself dictating curriculum as to what can be taught and what can be not taught. So should it matter whether the university is private or public? As long as the government itself is violating the First Amendment, it should not matter who they are dictating it to, right? Because that's one thing. The other thing is, why are state schools? I mean, are you suggesting that academic freedom should theoretically be more robust in state schools than private schools?
Okay, so here's what I would say to that. So of course, yes, when the government is intruding on the academic freedom, right, well, let's start with a private institution, right? That it raises a clear First Amendment issue. If it is the government that is restricting what may be taught in classes, what courses might be taught. Now, this is where things get a little tricky, right? Because private institutions in the United States rely on significant government funding, right, for research and other things. And so, again, this is a question of when is the government coercing private actors to not speak, and when is it simply saying, we're not going to provide funds to an institution that we think is harmful to society, right? Why would we do that? This is taxpayer money. We should be able to decide how we allocate that taxpayer money. And the ultimate effect of that is that private institutions change what they say, right? And so there's a blurry area, right, where the courts have to kind of distinguish between coercion and mere choice on the part of the government whether or not to extend a particular benefit.
So let's say that I'm the dean of the medical school at a private university, and I have $3 billion of federal grants to look for cure for cancer. And then in the same university, the political science department is full of people who are very critical of the government's position. So if the government cuts federal funding from the university for what the political science department is doing, but the money is being cut from medical school, why should that be upheld by courts? And for that matter, if I was the dean of the medical school, can I sue my own university for complying with the government by saying, look, none of us are teaching whatever the government has a problem with? You have a problem with the political science department, you shut that thing down. But why are you shutting down medical research? This is more important to save human lives and American lives than teaching about colonialism or not.
Yeah, I think there are definitely some potential First Amendment claims that might be made, and while that very specific issue has not been resolved, or addressed by the court, you have, for example, a case where the government funded legal aid attorneys, right? And in providing funding for legal aid attorneys, they said, we're not going to continue funding these attorneys unless you commit to not making certain legal arguments, claiming that certain of our actions are illegal or unconstitutional. And the court struck that down. The court said that it is basically coercive of these private professionals and their ability as lawyers to do their job, right? And it intrudes on their free speech. So I could see an analogy, certainly, in the case of similar actions with colleges and universities.
You know, the United States, if you look at the democracy index that is published by The Economist, the US has not been a full democracy according to them in this century. Okay, it's a struggling democracy. There are only 25 democracies, and the US is not one of them. In fact, there are democracies that the US made democracies, like South Korea, Taiwan, Japan, and Germany, which are considered full democracies, but the US is not. So what is clear is that since 2008 onwards, there has been a recession globally of democracies. So we have fewer democracies in the world today than we had in 2006, 2008. And even the quality of the democracies which are democratic is less. So there's a qualitative and quantitative decline in democracy. But the fact that you and I today are discussing academic freedom and the First Amendment, these are derivatives of democracy. Is this the last line? I mean, this is the last line where we are defending democracy? I mean, there's nothing behind this, right? If this falls, then it's the end of democracy. Would you?
I certainly hope it's not the last line. I hope the courts aren't.
If you lose the First Amendment, you can't even fight for anything else after that.
Right. I mean, exactly. I have some concerns about this current high court in the United States, but I haven't lost faith in the courts. Our system is clearly failing on many levels. The framers' design was, of course, that the three branches of government would push back against each other and act as checks against one another, and Congress certainly has not been fulfilling that role when it comes to the executive branch, and there are some real concerns about the judicial branch, right? And I deal in the world of sort of these doctrinal abstractions, which I think are quite important, right? I think these rules that develop over time are fascinating and important, right, when it comes to what that minimal language in the First Amendment means. But it is true, right, that it is certainly with an administration that is has the motivation, right, to plow ahead at a very fast rate when it comes to weakening certain democratic aspects of our system. There are limits to what the courts can do. The courts certainly have no enforcement power either, right? And in the case of of the courts standing up against what it's, the courts may see as executive overreach. There is always the question of whether the executive will abide by those decisions. So there is of course, I agree completely, significant reason to be concerned about the state of democracy, not only in the United States, which is where where my expertise lies, and across the globe. Um, but these principles do matter, and I do think the First Amendment is in some ways unique. I wrote a book about 10 years ago, arguing that at least the elites on the right have become quite protective of speech and First Amendment principles. Now, whether that will hold, I can't say for sure, but I do think it is one area where among the sort of in terms of judicial elites and scholarly elites, scholarly elites, there's a little more of a mix of viewpoint, but I think it's an area where there's still a strong belief in these principles on both the left and the right, among many judges and justices, and I do hope these principles are able to stand up in this very challenging time.
I didn't want to talk about the architecture of the US Constitution, but since you brought it up, the genius of the United States design is the horizontal and vertical division of power, federalism and checks and balances, right? So it is both, like you divide power between states and the federal government. And I didn't realize until recently that the US Constitution essentially gives unenumerated rights to the states, not to the federal government. That is, I think that's an incredible thing, actually, or to the people. That's what the Constitution says, that rights which exist but which have not been enumerated belong to states or to the people, not the central government. That itself prohibits an authoritarian, potentially authoritarian regime. But my question is that we are living in a very peculiar situation where political parties are capturing the state institutions. And as a result of that, they are neutralizing the genius of the US Constitution, where there are no checks and balances. Right now, I don't think that we have a checks and balances in the system. Yes, some of the judges, that's why we are doing judge shopping. That some judges might uphold their constitutional responsibility to check on the government, but some are not. So on top of that, we have all of these judges being politically selected, etc. Do you think that at some point we need to rethink the constitutional structure itself as to how we appoint Supreme Court judges for life, whether we need to have elections there, like in order to ensure that the checks and balances functions remain in place?
Yeah, I mean, I would certainly not go down the road of more judicial elections like that to me. I think if anything, what we need, there are a lot of reforms, right? There are a lot of the judicial reforms that I think, to me, offer the most potential are reforms, for example, that would not pack the court, right? Because that is, I think that's a unwinnable contest, right? Because under the Constitution, we currently have 9 justices on the Supreme Court, but that is not a number that's dictated by the Constitution itself, and so that number could be changed by law, but adding justices to the court to achieve political ends, I mean, to me, it's an unwinnable proposition, because it just means that the next time the other party is in power, they will do the same. That's not a productive solution. I think
with rising life expectancies, we could end up with a Supreme Court larger than the Senate.
Absolutely. I do think there are, though, reforms that are potentially promising. One of the most, I think, one of the reforms that I think makes a lot of sense would be putting a kind of 18-year term limit on justices. Now, whether that would require amending the Constitution or not is arguably unclear. It's likely that the Constitution would have to be amended to do that, because the Constitution provides for life tenure. But there is something called senior status for judges, and you could argue that you could create a system where after 18 years, justices automatically move to senior status, and they take a sort of a backseat role. And they would be replaced by a new justice, which would allow every president to appoint a Supreme Court justice every 2 years, which would result in a court that is more consistent with our and balanced according to our politics, right? It would so that's one I think reform that would be very helpful. I've even heard of the potential to make all circuit court judges, federal circuit court judges, Supreme Court justices, on a sort of a rotating basis. And the way it works at the circuit court level is there's a panel is chosen by lot. So if you argue your case at the federal circuit court level, the appellate level, in front of 3 judges, and they're chosen randomly from the pool of judges in that circuit. To have a similar kind of system for the High Court, by expanding the High Court to include all circuit court judges, to me is also a really compelling idea, because then there would not be knowledge beforehand as to what kind of ideological makeup on the court would be deciding your matter, and it would hopefully have the effect of depoliticizing the court's work, because it wouldn't be you would do away with the sort of judicial entrepreneurs who try to get a case to the court to achieve a certain outcome, because that outcome wouldn't be certain, because we wouldn't know what makeup the court would have. So there are, I think, a number of reforms that are interesting to me. I mean, there are reforms. This is outside of my area of expertise, when it comes to the party system, right? That we could talk about.
So I want to come down to earth a little bit, and just as I was about to log in to start this conversation, I saw a news item run by in which Tucker Carlson is saying that if the Department of Justice targets hate crimes, then he is calling for disobedience, civil disobedience.
Wow.
So yeah, so we are getting into the realm of rebellion. That's the next call after civil disobedience. He's being very careful, because if he had not said civil, then that could constitute hate crime. He could be in jail as a threat against the government, really. But do you think, from your understanding of how important the First Amendment is, and you are observing the same environment that I am, are you as concerned and as afraid? I have been a victim of this. For example, this channel that you're on is blocked by the Indian government in India. And so I have another channel. So now I have 2 channels. So I have experienced directly, the silencing of speech, but India doesn't have as robust freedom of speech laws as the US does. And YouTube and X are not, they are basically surrendering to Indian demands because they want to make profit in India. But are you concerned about how critical this whole challenge to the First Amendment is at the moment in the country?
Without a doubt. But let me say that I can't claim to be a huge personal fan of Tucker Carlson, but I would say, right, that I think that it is a a positive thing, right? And this is of course just an issue that is unfolding right as we speak. This question of hate speech, right? It is a healthy thing that on the right there is now seemingly a debate on whether the administration should go down this road of trying to prosecute hate speech, which again, according to the current interpretation of the First Amendment, would not be permissible. And you have this, because I think those kinds of obviously those kinds of debates are what make our system work. If it is just the Republicans versus the Democrats, the right versus the left, and there is no more nuance than that, then we're in trouble, right? But once we have the right arguing with the right and the left arguing with the left, I think we start to move into a healthier territory. So I hope that's a sign of something positive.
I think the right defending the First Amendment against the right is a positive thing. But the left opposing Mamdani to become the mayor of New York, I think, is degenerative. There's nothing positive about that. So thank you very much, Wayne, for coming on Khanversations and touching upon this critical issue and enlightening us. A lot of us talk about what is free speech and what the Constitution is, etc., without fully understanding what the constitutional and legal nuances are. And nowadays, all conversations are global, but clearly we are an outlier in how we understand freedom of speech. And I think the gap between the United States and the rest of the world might be reducing to the detriment of the US, I think. But nevertheless, thank you for enlightening us and throwing so much light on some of these concepts that are so difficult to, understand and also then translate them into policy.
Thank you so much for having me. I really enjoyed it.
Thank you, Ben. Bye.